I'm going to pose a question to each of them to start the discussion. I'm going to pose one question to each of the presenters, and then once they've responded, I'm going to open the floor to all of you. So you might want to build on some of the questions or have some of your own. I'm going to talk to each one and then give them a moment to answer. I hope those all work. Okay. So Nikita, I was interested to know, does the model that you use affirm or undermine traditional methods of conflict resolution? To what extent does your model do that? And maybe in the process you can also tell us a little bit about whether pursuing legal recognition for community-based paralegals is helpful.
Thank you very much. My short answer to the first question is that no, it doesn't undermine traditional justice systems in the country. In fact, it enhances those systems. And with respect to the second question, Sierra Leone managed to pass a legal aid act in 2012, which was viewed as progressive, and it sort of incorporates the mixed model that we have in South Africa. And one of the key provisions in that law is that the legal aid board, which the law sets up, would have paralegals in every chiefdom in the country. And these paralegals would provide legal advice and assistance to the paramount chiefs, who are the traditional authorities in those chiefdoms, as well as the inhabitants of those chiefdoms. And so, in a sense, it is clear that this particular model does not go against traditional authorities. In fact, it has been designed to enhance the effectiveness of these institutions. And that is what the law is trying to get at. Because we have seen challenges within traditional systems of lack of respect for human rights, particularly of women and children. And we think that with the presence of paralegals in every chiefdom where a chief exercises authority, the paralegal who's got some training on human rights, who's got some training on principles of conflict resolution, would add value to whatever services these traditional authorities are providing. So, in essence, it would complement that. Although I must state, as a caveat, that initially when the whole concept of community-based paralegals started, there was tension between them and community leaders because they felt that paralegals would come and literally take bread out of their mouths because they were making money out of exercising their traditional authorities, whereas paralegals were providing free services. And so for a while, there was this tension. But then after some education and explanation, they realized that the paralegals were adding value to their services. Thank you.
What I'm going to do is I want to pose a question to each of you that you can just answer in quick succession rather than a question answer as if I'm a teacher or something. I want to set the question also about recognition. To what extent is that important in South Africa for recognition of paralegals? And maybe also talk about what that relationship with lawyers. To Christine, I'm curious to know about how people responded to your choice to use inmates as the providers of law or information about law, and to what extent that, and how lawyers took that particular initiative. There might be other people who have also that curiosity. And then to Febby, I'm interested to see what has been the impact of the structural legal aid to structural change, because that was the essence of your paper. So what has shifted? And then how would you resolve that? How would you suggest we resolve some of the challenges that emerge in that setting? And then to Ahmed, we spoke a lot about access. Tell us a little bit about quality in dealing with people who are community-based. And then your last slide, I think, was about demand. So if you could tell us a little bit more about how we can increase demand in places, particularly for marginal and vulnerable groups of people. Thank you.
Okay, thanks, Marcella. On the first question of recognition, I think recognition for us is very important because it will help us, as I said in my presentation, to protect the sector, but also to protect the vulnerable people against vultures who might wake up in the morning and say, we are also paralegals. So it is important for us to know who are the paralegals, and that should be in the regulations. In regard to your second question, our relationship with the attorneys and lawyers, as we all know, that relationships are managed, and we have short-term relations, we have long-term relations, and I think over years we have had good relations with even private attorneys. That continues to grow because we make their work easier, especially those that are on pro bono, in the sense that we refer to them carefully screened cases, in cases where we could not resolve them through our method of conflict resolution. So it is an ongoing, it is a work in progress that we, from time to time, develop new relations with attorneys, and also to teach them about the importance of them plowing back into those communities, because most of them come from the same communities where you find vulnerable people. So it is also about us teaching them the importance of them plowing back into those communities.
As I have shown you in my previous slides, that in a case where Behani's approach was applied, we have impact to the new adoption of the procedure of legal standing, as well as citizen lawsuit in our civil procedural law that has never been there before. And also the citizen lawsuit on the case of migrant workers. It has driven government to pass the migrant worker protection bill. And about the case of a member of Communist Party, now member of Communist Party and their families are free to exercise their political right to vote and be informed. And also on the suggestion of that how we should anticipate the challenge, I made a 3 point that I believe that legal aid fund for one case should be based on actual expense rather than a fixed budget. So for a small claim case or petty crime, it can be fixed. But for strategic litigation and community legal empowerment, it needs to be based on actual expense. And the budget should cover non-litigation as well as litigation when needed in working one case. And also the last, legal aid organization initiates a public fundraising to anticipate independency and minimize possible intervention or restriction from the government. That's all.
Thank you. I think this is going to give us more time to explain our presentations. The first question is just the quality of the service can be provided to people living with HIV or care population. How we can ensure quality. My point of view is we need to focus more on training for lawyers, training for paralegals on provision of legal services, whatever the kind of service they provide to people living with HIV or TBs. It can range from legal information, can range from to legal advice, to court representation, informed distribution, and so on. But I think we need also to intense the training for lawyers, training for paralegals on the needs of the clients themselves. So if they know the needs of the client, they can provide them with quality legal service or legal aid. Also, another thing is we need to train them more about the confidentiality of the claims that they receive. So this can ensure a quality service. The other question, which was on the demand, how we can increase demand on legal aid or legal services. And this can take us back also to the point of the outreach of field outreach workers and paralegals. If we train more outreach workers, if we train more paralegals, they are the most likely contracting the people living with HIV, contacting gay-affected populations in community-based, programs, or in the street, or in their citizens, their communities. And I think if we focus on this more, this can increase the demand for legal services by approaching them. I hope this answers you.
Maybe others will have more questions. Thank you.
For me, when you talk about the reaction to using prisoners or persons in custody as paralegals, I'll say what we have is a mixed reaction. I've been privileged to engage at two levels, as an implementer of legal aid and at a policy level. And mainly in the main prison. And in the main prison is where it has really picked up, the women are still picking it up. And you find the courts appreciating the quality of documents that are coming from the prisons, because these paralegals are trained as drafters, they draft their bills, and the lawyers, the pro bono lawyers that we have, are also appreciating the quality of documents. They have to do less work. The court also says that they have less work. The prosecutors have been complaining they have more work, because now they have to be more prepared when these appeals are coming to court. So there's a sort of a mixed reaction. I'll say we are proud to have over 1,000 people released through this initiative. So for us, we consider it has actually worked. With regards to the lawyers, the Law Society is not concerned with the prison paralegals. It is more concerned with the community paralegals. That is where the conflict is. Because with the prison paralegals, to them, they have this notion that they are contained in some places, so they will not bother them as such. The problem that we have been having and is at the point of exit. Once you've served your 14, 15 years in prison, you've been trained as a paralegal and practicing it for the past, maybe say 5 years. At the point of exit, where do you go? Because that is the tool, that is the tool of trade that you come out with from prison. And our fear was that now they'll start turning into barefoot lawyers, mini lawyers, and maybe masquerading as lawyers. So we've been trying to talk to the civil society or the NGOs that are dealing with legal aid and see if they can be incorporated and have their training enhanced so that they can also now serve well on the outside. I hope that answers you.
It's really intriguing. Thank you very much. I'm going to take 5 questions first, and if you have a question for a specific person, say so. If it's for the whole panel, also say so. So I'm going to start on my left, and I'm going to do what some other one that I didn't give you now because it's easier. 1, Andrew, 2, 3, 4, 5. Okay, I'll do the 6th one.
Thank you very much, presenters. My name is Amos. I come from Rwanda. I'm the executive director of the Legal Aid Firm. We also run paralegal programs within our network. And I always have questions. And maybe I will not say the questions I have, 3 of them will be directed to but we can try to answer them because I know not all of us, I think, including the group, because I think they are very pertinent. They have been asked several questions in conferences that we don't seem to have solutions to them. But of course, the group will share their own experiences. So the first question is about remuneration for paralegals. And in my country, we are not able, and I know in most East African countries, paralegal programs are managed by NGOs. We are trying these days to work governments to include the legislation. And however much government can try to do that, I'm not sure if government will be able to pay salaries or remunerate paralegals. So this is something that this conference needs to. If we as NGOs, we are finding our own problems of financing our own programs. How about paralegal programs which are now being managed by NGOs? The quality assurance for the work of paralegals. Quality assurance for the work of paralegals. How do we manage? How do we ensure that the work of paralegals that they do is we are talking about quality work. Then the last question is about training, accreditation, and qualification of paralegals. These are issues that think they vary from context. Some have long periods of training for paralegals, others have short periods of training, others have accreditation processes, others don't have, others consider certification levels. So if we can, the question is there any standards, has there been any standards in any of the countries that is representative of training and accreditation? Thank you.
Number 2 was here.
Good afternoon, everyone. Well, almost afternoon.
Just
Yeah, my name is Dick Kuba, and I'm from Legal Aid South Africa. I just want to make some observations with regard to the work of paralegals. My own view is that paralegals are not being used as much as they should be used. And the problem is that there is no established profession of paralegal that is recognized. By and large, in most countries, paralegals are seen more as sub-lawyers or people who are supplementary to lawyers, not being themselves primary providers of legal services. But these professions are different professions. The work done by paralegals is not necessarily the same work that a lawyer does. I've had opportunity to interact with paralegals, and my observation is the questions that come to paralegals and the advice that they give are things that I may not be interested in dealing with, but that advice also, it may be advice that I'm not capable of dealing with. And lawyers are more trained to deal with more with litigation, whereas paralegals know how to resolve issues in ways that lawyers may not know how to resolve them. If I can give the example of a trauma unit in a hospital. Can you imagine that every time there is a big accident, if all the doctors in the trauma unit had to go out to the scene of the accident and go and stabilize people and put them on stretchers and transport them by ambulance and bring them to the trauma unit? It is not their work. That is the work of paramedics. And I can tell you now, if you got a doctor to that accident scene, some of them will make a very poor job of it. But also it is not cost effective. It is also not cost effective because you want the doctors in the trauma unit doing what their core function. I'm giving this as an example so you can see how within the same professional pipeline you can have distinct professions. In the medical field, you do have the distinction, but not in the legal field for one reason or another. Now, in South Africa, a couple of years ago, they introduced a primary healthcare system. And they said, if you want medical care, you cannot just go to a district or provincial hospital. You must first go to a local clinic. And the local clinic will attend to you, and only if they cannot attend to your issue will they give you a referral to the government hospital. This is exactly what should happen in the legal profession. So the paralegal profession were to be established as its own distinct profession. What should happen is people must first go and see a paralegal. And only if the issue cannot be resolved by the paralegal should they be referred on to the lawyers. We always complain that lawyers are on heavy caseloads. I'm not surprised because most of the time is spent doing things that they shouldn't be doing in the first place. And I would like to know from the panel, yes, what efforts are being made to lobby for the establishment of a paralegal profession as a separate profession, not just a vague promise like we've seen Mr. Munguni quote there in our own legal practice. When that act was still a bill, there was initially a concrete effort to establish a paralegal profession with certain rights of appearance. But as you can see, that has now been watered down to just a hint that maybe there will be consideration for the paralegal profession to be corrected to legal practice.
Thank you very much. It sounds like you've got a job that paralegals might like to use your services. But we're going to ask them to comment on whether you're a suitable candidate. Okay. I know there was a question. Number 3 was there. Thank you for defending your space.
Thank you very much. I have 2 questions. And the first is to Sankita. And the question is, he mentioned the issue of paralegals providing advice not only to accused persons in traditional courts, but also to the traditional leaders. I want to know how this has impacted and on the delivery, access to justice and delivery system. I think that some research on that would be very productive. And the second question follows from that. Now, in traditional justice systems, first of all, we know that generally 80% of our people are still governed by traditional law, and that mostly 80% of cases are heard and determined in traditional courts. But also, more than 80% of people in prison, prisoners, are sent there by traditional courts, and the statistics are there to speak for themselves. So basically, when we talk about legal aid and access to justice, there is the wide range of majority of people who are cut out of what we refer to as traditional legal aid because lawyers do not have audience in these courts. They cannot be represented in traditional courts. So therefore, and now this is to the general panel. Yes, are there any practices or experiences in relation to paralegals? Are they able, or have they broken the barriers, that have been placed in relation to the traditional legal representation as we know it? And if not, are there any innovations? I think what Sankita has mentioned is an innovation which I think probably may or may not have worked well. But are there any other possible innovations probably appearing as part of the participatory process and speaking on behalf of accused persons?
Thank you very much. Thank you. Next time,
I'm Tony General from Bhutan. I don't have a question as such, but I would like to share some of the experiences that I was having. Regarding these community-based services, we have this institution called Bhutan National Legal Institute, which is taken care by one of the princesses, and we have tried under her. They have done really good research all over the way, because we thought that ultimately it is service, and then how much would you pay for that? What they have done is that we have done a survey all over the country, and we have tried to make use of the local leaders who are paid by the government, and also the local administrators who are working under the local leaders. So we have engaged the judges, the paralegals who have multiple experience involved. So we have hired them, and then we have done a regional-based training of all these local leaders and the local administrators. So then we did a research on the customer practices, whether these customer practices are viable or not, whether these are in line with our domestic laws or not, whether these are in line with international laws or not, which are bad. We inform them that we have to use that because it will breach the domestic law or international. But the customer practices which are good, we encourage them to use it as affiliation. So all of them are trained all over the country. And now, since these people are the representatives of the people at the local level, if they have any problem, we make them responsible to solve this problem. So they don't have to pay anything to the community because they are paid by the government as a local leader. So recently even the government has raised the payouts. It may not be in that, it is not because of extra service. But anyway, they are now paid handsomely. So that's why we are using one person who can give multiple services to the community. Moreover, the local leaders and the local administrator, they know the individuals in the society. So that's why it has been very effective. They have done all over the country, and now they are again trying to review that what they have done. Other thing is that what they have to do is that they have introduced the law clubs in the schools, within the schools. Within the school, the students who are good, in reception and receptivity. We taught them basic things about law, how to solve issues if there is a problem within each school. So even these students are not paid, but they are students. And this has been doing, we have been doing this for about 4-5 years. 4-5 years. And it has been working very well. So that's why then the paralegals are also there. But right now, what paralegals will do is that since we have not instituted bar council bar association, some of the paralegals who are good are also allowed to practice before the court of law on a temporary basis, on terms and conditions. But later on, once you have bar council as all the time of the service, we need to do that the service of the paralegal. So that's why these are the alternatives that which we have in our country. If that would also be relegated, it is viable within the other parts of the world. So just want to share this with you.
Thank you very much. Thanks to the presentation.
Number 6, I believe.
5 and then 6. And those are probably going to be those are going to be the questions. We will be close to our close down time, and they will respond. So your questions can be slightly shorter.
I'm next.
Yes, you are. You're number 5.
Me. My name is Shinoy Ipieni.
Oh, yeah.
I'm number 5.
And then number 6 at the back. No, I'm not going to tolerate another question. Just 5 and 6.
My name is Shinoy Ipieni, Legal Aid Council, Nigeria. I'm not going to throw any question. I just want to share our own community-based approach for legal aid in Nigeria. We have 36 states, and just like what everybody has been saying, lawyers are generally concentrated in the center. But the people that need the services most are people at the villages and the lesser people whom may not even have the privilege of knowing that such services or legal aid exist. So what we do is we do some sort of street dancing. We dance through the streets, and while dancing through the streets, we share the plates. Some people that cannot read, we still have a large chunk of people that are illiterate. We discuss with them. We explain to them most of their constitutional rights, especially the basic 4, that they have the right to remain silent whenever they are being arrested by the police. They have the right to a counsel anytime. You know, those are the basic ones. Because just like what we all agreed upon, the right of citizens, the breach of their right almost always starts whenever they are being arrested by the police. And the police will now compel them or force them to give their statement without having access to a lawyer or without informing them that they have the right to remain silent. Then another thing we try to do is, the police themselves do not even know most of the laws. So we try to meet with the head, the commissioner of police in our own state, the DPOs, and we try to inform them, look, what the people are doing is a bit unconstitutional. They ought to inform these people of their rights. If they should not inform them of their rights, whatever statement that is taken from them, whatever is taken to court, such a statement will be expunged. And we've done that on 2-3 different occasions. And by force now, they are trying, though initially when they come to court and you ask them that the people have to inform him when he was arrested that he has the right to remain silent, they say, why would I tell him such? Once I inform him that he has the right to remain silent, he won't say anything. And the judge will say, good. So that means you have breached his constitutional right. But now they will come to court and tell you, yes, we did it. And now the judge will now be in the middle. But the general sensitization of what we are trying to do, we give them our numbers, because coming down to the center, the office is located in the state capital, and we have other rural areas. So we try to give them our numbers. So anytime you can contact us Monday to Saturday, you will have to pay us for Sunday. And whenever we're being contacted, we rush down. And part of what we do is we have a telephone number of virtually all the DPOs. So, because most of these things that are being done, DPO means divisional police officers. At times, it is these constables that break the rights of the citizen without the superior police officer being aware. But once you have the number and if you call me, oh, I'm in so location, the police have been just arrested, and I said they should give me bail. They said no, they won't give me bail, that will be detained. Once they call us, we try to get in touch with the DPO, and the DPO will immediately order that such a person be released. So, Because now the issue of paralegal per se is not yet deeply rooted. So what we try to do in Nigeria, what we try to do is we meet with community leaders too, and try to tell them that, look, whenever your people approach or whenever you discover that their rights are being breached, because when you're talking about the issue of legal aid, the police, they are a major partner. Because they are the major people, that is where it starts from. So, the community, want to inform the community and the community head, and they are aware of what is really going on. They always give us support. So I think people that, what we have in Nigeria, that our paralegal is not yet very, very strong. We can do this, go on the street, meet with traditional rulers, and try to sensitize them by dancing on the road. You call their attention when you see somebody like me dancing on the road. You say, what's your problem? So I would have to tell them that, look, we are trying to tell you that you have rights. Government gives you rights, and these rights are basic rights that anybody cannot take away from you.
So these are quite different ways of bringing awareness to what are rights in Nigeria, in the absence at the moment of paralegals.
Yes.
Okay, we're going to hold that thought because there might be more people who want to ask you questions. So if I can, is there a question that you have?
No, just to share the Nigeria experience.
Thank you for both of you. The last question at the back, and I was a bit harsh on the person there, but if there's time, I might just give you a chance.
Well, I'll try to limit. I'll just limit myself to questions. So
you still in the back. You can ask your question.
Yes, it has to do with Christine's presentation.
Okay.
I am very intrigued by the change in their law of evidence, that the confession statement has to be made before a magistrate court. I hope my country, Ghana, can learn from that. But the paralegals in prison is another interesting one. I don't know what the system is in Kenya, but in Ghana the law is that, even though it's probably not exactly practiced, the awaiting trials should not be mixed with convicts. So, for persons who are supposed to be on remand, the inmate paralegals may be useless to them. What we have tried to do has been to train prison officers themselves who are taking charge of the prisons to help with preparation of appeals and preparation of motions for bail if the people don't have access to lawyers where they are in the prison as well.
Can I ask you to just round up, because we've got just a few minutes to give them a chance to respond, and I really want to get to those questions.
Yes, the other thing that there was talking about paralegals. It would be useful if we could have some curriculum for training paralegals. I don't know where we can get that standardized curriculum. Well, my friend has been at it for a very long time. I've been asking about what the curriculum is, but it has been different from country to country. Can we just have some standard that we can use for this profession?
I'll attach that question to the one that Andrew's asked about training and standardization. I'm really glad that all of you heard the questions, and I'm not going to waste time in repeating them. Will you just say which question to answer and which comment to respond to as you ask? So we can start with Ahmed.
I would like to respond to the question raised by our colleague from South Africa about how we can include paralegals in our work, or how we legally can include it. I think there is a lot of, around the world, there is a lot of paralegal institutions who can train paralegals on law and law representation, at police stations and so on. And paralegals, through these institutions, they are public institutions, non-profit institutions, they can obtain a certificate and they can practice their work as a paralegal. So this is one of the solutions we want to empower them in their work as a paralegal. And this is very similar to the idea of paralegals that you explained to us. So I think one of the solutions is we have to advocate with the governments in having public paralegal institutions train paralegals on legal information and legal advice, and also informal representation.
Let me answer number 5. Then I will touch on what you evaluation of paralegals within the system and what we're doing in Kenya. And I will tie it in there. Now, for us in Kenya, we do not have that segregation per se for persons who have been held in remand and convicted persons. The segregation is supposed to happen in the prison blocks, within the prison setting. So anytime when you're going to the prisons, when we're dealing with the paralegals that we are training, we train those who are already convicted. Because they are now free, they are freer to move around the prison as compared to those who are being held in remand. That is how now they can access them. In addition to that, we've also trained the officers, the prison officers, as paralegals, so that they can also be in charge of the prisoners themselves. There's a lot of mischief that goes on, and that is one of the ways that we cure it. With regards to recognition of paralegals within the system, right now in Kenya, our constitution provides for what we call an intermediary in criminal offenses, especially when you're dealing with children and maybe SGBV cases, and when you're dealing with child offenders. Now, we have moved to the court to seek an interpretation of who an intermediary is, and we ask the court if a paralegal can be used as an intermediary. In the prosecution of FGM cases that I'm doing now, I use social workers and children officers as intermediaries, and the court have actually accepted. So that is the thing that we're waiting for. Once it is passed, then we will know their place. We have pursued a general curriculum using the Paralegal Association, network in Kenya. And we have brought them all, and we're actually developing a training curriculum for all the paralegals in Kenya. That is what we've done so far. And I think it can also, maybe if you can think, it can also work.
Thank you, Michelle. I will attempt to answer the two questions from our ally and Andrews over there. I will start by saying the lobbying has been continuing for a long time. For instance, the Legal Services Charter, which is a document that was adopted by government in 2007, spells out clearly the importance of the paralegal. And the Vision 2000, which was an earlier document, also talks about strengthening relationship with the civil society organization, but in particular the paralegals. And the paralegals have been part of the development of some of these documents. So, as you said, that some of these things have been watered down. I think if you have seen the earlier version of the legal practice bill, the role of the paralegals was clearly spelled out there, and later it was removed. And then we started fighting again to put our agenda on the table, and that is why you see the Legal Practice Act now has got a blank page for us that we need to work on. And I think we will need your support. Correct. The second question from Andrew is around government playing a role in the training and the programs of the paralegal, I think the quality assurance and the accreditation. I think one of the reasons for us to be regulated by government is precisely to address some of those issues. But as an organization, as a sector, the reason for us to establish this national association as we have one now is particularly to deal with some of those issues in the absence of a statutory regulation. So it is very important for us that these issues, because the issue of accreditation, the issue of quality assurance is very important to us. But we want to see that as being not just from us as an association, because another association can come up with something else. So, but it must be something that is implemented.
Thank you very much. I would say by a quick way of answering the issues raised by Andrews, that the 2012 Legal Aid Act of Sierra Leone addresses all of these issues. And we're thankful to the support of the Society Justice Initiative Professor Marcella Naidoo, who helped the country develop that particular piece of law, because it is progressive and it addresses all of these concerns that you've raised. It formally recognizes paralegals as providers of legal services in the country. It also sets out means of accreditation and quality control and sorts of things. And it does not just leave to the government. The Act creates a board which has representation from CSOs that are providing paralegal services and a range of other actors. And this board is responsible for setting the standards that would govern how paralegals operate. So the law is a good law, and it has dealt with all of these issues in Sierra Leone. What remains to be done now is implementation, and that's why we are fighting. Because if it's implemented to the letter, then it will be a system that could be compared to the South African system, which and has to be backed by law. The question asked by Roland with respect to the impact of paralegal interventions in traditional justice. Now that has not been measured, but we have seen examples of improvements in the way traditional authorities dispense their services. Now, one key thing I need to make clear here is that we have traditional courts which are actually under the supervision of the formal judiciary. And then you have what we call chiefs courts, which are governed by chiefs. And the chiefs courts are not supposed to adjudicate on issues, but they almost always do that. And so one of the key uses for paralegals with chiefs courts is to ensure that they comply with the law and stick mainly to arbitration and mediation and not adjudication. And so we've seen that where we have paralegal offices operating, they're able to ensure that there is a diversion of matters, that cases that chiefs should not adjudicate on are diverted into the traditional court system where there is a court chairperson that has a clearly and statutorily defined mandate to adjudicate on cases. We do not have scientific studies of that, but then we do have anecdotal evidence of the improvement of the functions of traditional authorities in the country.
Thank you very much. I think we've had lots of food for thought. The questions of paralegals. Sorry, did I miss your question?
It's not a question.
It's another comment. Let's make it short. Please.
Thank you for giving time. I'm R.B. Santiago from the Philippines. Although I have 3 points, but I'll really make it short. First point is that there are different uses and different types of paralegals. And in the topic today, we're talking about community paralegals who are stakeholders within the community. My appreciation is that they are not the paralegals who are like assistants to lawyers. Second point is the context was greatly explained by the first speaker, that there is a lack of lawyers in the area. And the purpose of the paralegal there goes beyond legal aid, because it's actually to empower the community. And getting paralegal training means that they are able to do what is needed by the community. Like for example, with the ones in prison, most of the time in jail, the inmates or those who are detained do not have a lawyer to process their case. So having a paralegal could help them in documenting these cases. And I guess that goes to my third point, that having a community paralegal goes beyond the issue of just legal aid, because it addresses community problems, like what was mentioned by our colleague from Indonesia. It precisely could address structural problems, because it helps the paralegal educate the community in order to negotiate with local government authorities, for example, for problems that they may be facing. Thank you very much.
Thank you. It's a very good summary of what has gone, and it helps me to just bring to the fore that I think paralegals, or what the speakers have certainly done for me, is to remind me how community-based paralegals are where it's happening. It's out where there are new issues coming up, where things are changing within communities. Community paralegals give us an opportunity, almost like the canary in the mine, to know that those expectations of the law is changing. People's experience of justice is not satisfactory. It gives us opportunity not only to deal with things in a litigious way, but also in ways which allow for community engagement to solve problems, which is probably cheaper than if we stand in court. And because we started with one speaker saying it's often about cost, and sometimes the cost can be averted by dealing with the problem at source rather than raising it all the way through a court. So community paralegals clearly have an important role to be as part of the big stakeholder of the profession that is the law, but also that space that is the place that we live. I wanted to take this opportunity to thank our speakers for making the effort to prepare and getting their stuff here on time. Thank you so much. It's really helped me. I want to thank you. You've been an amazing audience, and if I was a little bit draconian, it's only because my bosses are really draconian. So I've taken on the persona. That's people like Lee and others, because I was sitting there watching, quality assuring me in the moment. I want to just hand a token of thanks to our speakers. I'm sorry it's quite heavy for your luggage. I hope you don't have to ditch any of your other good clothing for our books. I hope you enjoy reading them and you find them helpful. And for those, just to say thank you once again. Those of you who will be leaving the conference today, just a couple of reminders again. The plenary will be after lunch, so please do go. It's important that we catch up and hear what the conference has resolved. The second thing is, don't forget about your booking out. The third thing is the movie that's on. And finally, you have some material. And actually, what I want to add something. Today is actually a special day for South Africans. It's the date of what we call Freedom Charter Day, the 26th of June. About 59 years ago, we wrote this document called the Freedom Charter, which helped us steer our way to some extent and shaped even our legal system because it embodied the desires of the people, how they wanted to see our country. So it's quite an important day, so do remember that. It's the basis of, well, it gave rise to our constitution, which is the basis of our democracy. And then finally, for those of you who will be staying, I'm doing a little bit of tourism here. Constitutional Inn is not far away. It houses our constitutional court. Those of you who have a day or an hour, it is an amazing place. It's a beautiful building. And it is our seat of our ultimate justice, so please do go and visit it. And I'm sure you will be as inspired as I am when I visit as a layperson. Thank you very much.